welcome to the 285th session of Legal Empowerment Through Interaction lecture series. The journey continues. After a brief break, we are back, and what a way to be back. The entire family is here, the Letils family. It's a wonderful reunion of all the family members. We have always, during COVID times, we had it every day, then became weekly, and now the new normalcy, and we are back to our own the things that we are to do. And of course, time does not permit everybody to come. But today, we have taken time out on a very, very important and interesting topic, that too on its Golden Jubilee. Kesavananda Bharati, we are revisiting it, and maybe the equal number of judges or opinions will be here today also, because we have got an array of eminent faculty speakers. Maybe welcome Justice Kurian Joseph sir, Justice Dr. Pushpendra Singh Bhatti sir, Justice Roshan ma'am, Justice Seetharama Murti sir, Justice Nagamuthu sir, Justice Rajive Bhalla sir, and Justice Anand Venkatesh sir, who will be concluding the entire evening. And apart from that, we have Justice Ramkumar sir. We are privileged with your presence, sir, and Justice Ramashan sir, Justice Paramjit sir, and all of you wonderful participants. So, on this topic, if I am to say something, I'll be taking time out of all this personalities. So, straight away, may I request Justice Kurian Joseph sir to the introduction.
Thank you, dear Shyam. At the outset, I must congratulate you for this never-ending journey. I'm sure we have already gone to the Guinness Book, I'm sure, and we must be breaking all records in having the maximum number of webinars on carrying the topics, possible topics under the sun touching on law. It's very illuminating, enlightening, and quite useful for the participants. And these are actually used by generations, are going to be used by generations. And the young generation of and other lawyers were not unable to join now, but since they are available on YouTube, on YouTube, I'm quite sure all of us would be benefited to refer for, because this is a very great source of reference more than anything else. The type of preparation the speakers have made and the type of interaction the participants have all made these sessions quite rich. I myself have been an active participant in some of the sessions. Unfortunately, I could not make it during for the old sessions. But I'm sure some of you, including my some of my beloved brothers and sisters, have been all through in these sessions also. So, my dear and beloved and esteemed sisters and brothers and members of my beloved fraternity of lawyers and experts, and law students, and gentlemen who are here to participate in this session on Kesavananda Bharati. I don't want to any elaborate investigation into, because what is Kesavananda Bharati judgment itself, its specialities, its uniqueness, it's strange on many aspects. I'm sure our Premraj will be inviting our attention to many of those topics. So I don't want to go into that. But I only want to make one caveat. Is it revisiting or reiterating? Or reaffirming, whatever we call it. When we say revisiting, it sends some signal. But I would like to send a different signal saying that it is time that it is the time that we reaffirm on what is the basic structure of our constitution, which actually has constituted our nation. So this is the only thing I would like to have a sort of introduction on the topic. But I would like to introduce a dear friend of mine, Mr. Yes, please mute all your phone gadgets. Yes, a dear friend of mine, Mr. S.K. Premraj Menon, a very illustrious lawyer in the High Court of Kerala, and finding himself to the High Court for more than a decade. And he's a great guru for several students. And I call him a walking encyclopedia. We have 2-3 walking encyclopedias in the High Court like this. For any topic, you just call them, they will give you, as an encyclopedia gives you, they will give you the correct answer or correct reference. And if not, they will enlighten you slightly later after clarifying the position. He is a fifth generation lawyer, so it is in his blood. That is the advantage. His late father was a renowned lawyer, and his mother, Chandakumari, before whom some of us practiced, and I myself have appeared before when she was a district judge, when I was a lawyer. Chandakumari, and is known as woman, and he has been a topper in all his classes, and is an awardee of a scholarship from Cambridge. So I have many more things to say about Premraj Menon, but Premraj Menon is not the center topic here. It is Kesavananda Bharati. So let me take myself this judicial restraint of going more into Premraj Menon, who is a dear friend of mine, who is known to every one of us, and is a very known legal jurist, I must say. So with this small introduction, over to you, Shyam. You can take forward the proceedings, and God willing, I can also be part of the discussions which come later.
Thank you.
Thank you. All the best.
It is indeed a pleasure. Today, the start of the day, the speaker, Prem, after what Justice Kurian Joseph sir has said about you, nothing more to be added by me, but thank you, my brother. Please, over to you.
Good evening, all. And my humble salutations to all my gurus who are present here. I'm really honored to have had this opportunity to address this distinguished audience. Firstly, let me express my profound gratitude to Justice Kurian Joseph for the kind and most generous words he has showered upon me. Sir, I'm just humbled, and your encouragement goes a long way. I thank Justice Kurian Joseph, Justice Pushpendra Singh Bharati, Justice Anand Venkatesh, Justice Kumar, Justice Roshan, Justice Seetharama Murti, Justice Rajive, Bhalla, Justice Nagamuthu, Justice Ramakrishnan, Justice Paranjit Singh, and each one of you for having lent your precious time on this Saturday evening. And I'm equally delighted to see Mr. Surendran Patel, a Keralite who is now a judge in Texas, United States. Now, I would share my limited understanding of the evolution of basic structure doctrine and the theory of implied limitations, which evolved 50 years back, and any shortcomings may kindly be forgiven. And I'm sure that all my flaws that would be remedied by the throng of those eminent judges who would speak after me. I will try to be as brief as possible, but as all of you know, the topic is a huge one which cannot be deliberated within a very short span, and a mere gloss over may not suffice. Now, the cause I celebrate His Holiness Kesavananda Bharati, Sripada Galvaru, and versus State of Kerala, which is reported in the year 1973 at page number 1461, which gave birth to the basic structure doctrine that was pronounced by the Honorable Supreme Court of India on 24th of April 1973. And now we commemorate the golden anniversary of that illustrious judgment. Now, on this occasion, at the very beginning, I feel it most appropriate that we equally remember the legendary legal luminary, Nani Palkiwala, the colossal intellectual who has given us all these fundamental rights. And without this great man, India would have never known the true democratic freedom in its entire legal history. So this is the great man who has given us all the fundamental freedoms we enjoy. My pronouns to him. Now, our Vice President, Mr. Jagdeep Dhankar, who himself is a designated senior of the Supreme Court and who had been practicing before the Supreme Court till he assumed office somewhere during 2019 as governor of West Bengal, he recently remarked that in a democratic society, the basic of any basic structure has to be the supremacy of the mandate of the people. And that being so, the primacy and sovereignty of the parliament and the legislature, they are inviolable. Now, he severely criticized Kesavananda judgment on the ground that it compromised the parliamentary sovereignty, and in the later years, the Supreme Court, basing on this basic structure doctrine, the Supreme Court has been creating judicial supremacy, according to him. And now we witness the ongoing tussle between the judiciary and the government over the collegium system of appointment of judges to the High Court and the Supreme Court. Now, the renowned constitutional historian, Granville Austin, who had authored two seminal political histories of the Constitution of India, in one of his books, he has written the unusual happenings that has taken place in the run-up to the Kesavananda Bharati judgment, some of which even cast a shadow of doubt on the entire process. Now, I don't intend to cross the proverbial Lakshman Rekha. Right from 1950 itself, we have been witnessing the unending tussle between the legislature and the judiciary over their supremacy. And the Kesavananda Bharati judgment that arises from one of such clashes between these two paramount democratic institutions. Kesavananda judgment is very, very unique in our legal history for several reasons. Now, this was the first time when a case was heard and decided by a 13 judges constitutional bench. 11 separate judgments. The only judges who did not pen separate judgments of their own were Justice A.N. Grover and Justice A.K. Mukherjee. Because Justice Shelag spoke for Justice Grover, whereas Justice Hegde, he spoke for Justice Mukherjee. And at that point of time, the total strength of the Supreme Court was 16. Justice Alagiri Swami, Justice Dua, and Justice Vaidyalingam, they were the judges who were not on the bench in this case. In fact, Justice Dua and Justice Vaidyalingam, they were appointed as ad hoc judges post-retirement. Now, Chief Justice of India at that point of time, S.M. Sikri, who was the first judge who was directly elevated from the bar to the apex court, he headed this 13 judges constitutional bench. And the case was heard for a span of 68 days, starting from 31st of October 72 till 23rd of March 1973. And prior to the Kesavananda Bharati judgment, you had no single case anywhere across the globe where any court had struck down any constitutional amendment. And this case was nothing short of like an all-out war, which was fought on diverse turfs of constitutional law. Significant enough to call for a constitution of the 13 judges bench. Why? Because Golaknath, I would come to it a bit later, that was 11 judges bench decision. So the parties to the judgment, they put their best foot forward, employed the most proficient lawyers of the land for this ultimate showdown. Now, Kesavananda Bharati, he was represented by Nani Palkiwala, C.K. Daftari, and M.C. Chagla, who were assisted by Fali Nariman and Soli Sarabji, with the adversaries being led by H.M. Sirvai, the great jurist, assisted by T.R. Andyarjuna. And there were, of course, other counsel, leading counsel included Niran Dey, the Nellen Sinha, Baira Reddy, L.M. Singhvi, and so on. And Palkiwala argued for 30 days. He was followed by C.K. Daftari, M.C. Chagla, Soli Sarabji, and other counsel. And on the next day, H.M. Sirvai, he commenced his reply submissions. Now, the issues and resolutions in this case were notoriously complex, but it is widely agreed upon the fact that it was Nani Palkiwala who stood the tallest at the end of this bitter fight. Palkiwala, he was at his forensic best for all the 30 days he argued, out of the total 68 days. And Justice H.R. Khanna had on one occasion even said that Palkiwala's performance in this particular case and the heights of eloquence to which he rose have rarely been equaled and never surpassed. And the case was taken up for judgment. The apex court ultimately comes up with a 703 pages of voluminous judgments in 2000 and odd paragraphs. Now, the judgment which is reported, All India Reporter, that contains an introductory editorial note, the case summary, head notes, etc., spanning to 19 pages, 8 pages of cited judgments, and 2 pages of the list of lawyers and the interveners. And the events which have led to this famous judgment, as I already told you, that date back right from 1950. The ruling Congress Party's electoral promise, one should not forget, that was one of implementing the socialistic goals of the Constitution, which is seen contained in Articles 39B and C, that called for a fair distribution of resources of production among all the citizens, as well as for the prevention of wealth concentration in the hands of a select few. Several state legislatures, they came up with certain measures of agrarian reforms, whereby you had the Bihar Land Reforms Act of 1950, you had the Madhya Pradesh Abolition of Proprietary Rights for Estates and Alienated Lands Act of 1950. Similarly, you had the Uttar Pradesh Zamindari Abolition and Land Reforms Act of 1950. And all these statutes were challenged before the respective high courts on the ground that all these statutes breached fundamental rights. The Patna High Court struck down the Bihar statute, unconstitutional. The Allahabad High Court and the Nagpur High Courts, they upheld the validity of the corresponding legislations in UP and MP. Now appeals thereto were pending before the Supreme Court. Parliament comes up with the Constitution First Amendment Act, 1951. Now this was petitioned under Article 32 of the Constitution. And a 5-judges bench in Shankari Prasad Singh versus Union of India, AR 1951, Supreme Court 458, dealt with the challenge against this amendment, which was passed by the then Provisional Parliament, which inserted 2 articles, Articles 31A and 31B. And those were sought to be declared as ultra-vires and unconstitutional, because those 2 provisions, in fact, limited the scope for the right of property, which was at that point of time a fundamental right, but Article 19(1)(f) as well as 31. And we know pursuant to the Constitution 44th Amendment Act of 1978, the right to property that was removed from the list of fundamental rights, and it was elevated to the status of a legal right. Now, 31B was a very draconian provision, under which if any law is put into the 9th schedule, irrespective of the fact that it was struck down by a constitutional court, even then it goes unchallenged. And it is insulated despite violation of the fundamental rights. So in Shankari Prasad, the bone of contention was that the amendment violated Article 13, Clause 2, which prohibits a state from making any law which takes away or abridges the rights conferred by Part 3, also stating that any law which is made in contravention thereof shall, to the extent of such contravention, be void. Now, issues as to whether the Parliament could amend the Constitution, whether the fundamental rights could be amended, if so, what is the extent to which it can be amended under Article 368? Several issues were raised, and Justice Patanjali Shastri, now he spoke for the unanimous bench, and the bench ruled that the power of Parliament to amend the Constitution under Article 368 also includes the power to amend the fundamental rights, and that the word law, which you see in the context of Article 13, it has to be taken to mean rules or regulations which are made in the exercise of ordinary legislative power, not the amendments to the Constitution, because it is made in exercise of the constituent power. And with the result that Article 13(2), that does not affect any of the amendments made under Article 368. And therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment. And such a law will not be void under Article 13. Anyhow, the question whether the latter part of Article 31B, it is too widely expressed, it was not argued. And luckily, the bench also did not express any opinion upon it. Now, several amendments started flowing in. Now, the 9th schedule gets populated by a large number of agrarian reform laws. Another 5-judge bench in Sajjan Singh versus State of Rajasthan, AR 1965, Supreme Court 845, that dealt with 6 writ petitions challenging the Constitution 17th Amendment Act of 1964, which amended Article 31A and further adding around 44 statutes to the 9th schedule. Virtually, Shankari Prasad was revisited and Shankari Prasad upheld. Chief Justice Gajendra Gadkar, who penned the majority for and on behalf of himself, Justice Vanchu and Justice Raghubir Dayal, and he held that the power which was conferred by Article 368 includes the power to take away the fundamental rights, which you see under Part 3. And that fundamental rights, they could not be said to be eternal or inviolate or beyond the reach of the legislature. I mean, beyond the reach of the Parliament. So, it is within the reach of Article 368, even if the powers to amend the fundamental rights were not included in that article. So the Parliament can make any suitable amendment of those articles and take away all those powers. Now, a separate judgment was spent, one by Justice Hidayatullah and the other one by Justice Mudholkar. Both of them, of course, concurred, but raising some doubts on the unfettered power of the Parliament to amend the Constitution and curtail the fundamental rights of the citizens. Now, Justice Hidayatullah, he found the reasoning in Shankari Prasad to be unacceptable, though, of course, he refrained from expressing a final opinion, to which Justice Mudholkar he supported, but with additional reasons. And he too did not express himself finally on the broader question. Now, a close reading of Sajjan Singh shows that much prior to this Kesavananda Bharati, Justice Mudholkar, he had indicated about the basic features of the Constitution, which I shall advert to a bit later. After Sajjan Singh comes the 11 judges Constitution bench in IC Golaknath and others of the state of Punjab, AR 1967, Supreme Court 1643, which considered 3 writ petitions. Fundamentally raised question was regarding the validity of the Constitution 17th Amendment Act of 1964. Now, the lead petition was that of the Golaknath family, and the statute involved was the Punjab Security of Land Tenures Act of 1953, which declared the families of around 418 standard acres to be surplus. And this was sought to be declared as void because it infringed Article 14, 19(1)(f) and 19(1)(g). And seeking the First Amendment Act, the Fourth Amendment Act, and the 17th Amendment Act, insofar as they affected the petitioner's fundamental rights, they were unconstitutional and inoperative. Chief Justice Subbarao, he delivers the majority judgment. For and on behalf of himself, then there was Justice J.C. Shah, Justice S.M. Sikri, Justice Shelat, and Justice Vaidilingam. Whereas the minority judgment was penned by Justice Vanchu, for and on his own behalf, as well as Justice Bhargava and Justice Mithar. Justice Bachawat, Justice Ramaswamy, and Justice Hidayatullah, they wrote separate judgments, of which Justice Hidayatullah, he takes note of the Universal Declaration of Human Rights, finding similarity with Part 3 and Part 4 of our Constitution. And he observed that they were manifestos of a man's inviolable and fundamental freedoms. He compares the Weimar Constitution, the Commonwealth of Australia Constitution Act, as well as the constitutions of several states like United States, Peru, Brazil, Poland, Latvia, Mexico, and he compares that with the Constitution of India. And of course, agreeing with the majority view that the fundamental rights, they were outside the amendatory process, if the amendment seeks to abridge or take away any of the fundamental rights. And he went on to hold that Shankari Prasad and Sajjan Singh wrongly conceded the power of amendment over Part 3 of the Constitution on an erroneous interpretation of 13(2) and 368. Now, thus by a fractured majority of 6:5, Shankari Prasad and Sajjan Singh gets overruled, holding that the Parliament cannot amend the fundamental rights enshrined under Part 3 of the Constitution of India, as it was kept beyond the reach of the parliamentary legislation. Now, the word used was, it was transcendental and cannot be amended even by the amending procedure which was set forth in 368, which we saw. And therefore, the amendment of the Constitution, that would be a law for the purpose of Article 13. And the first, the fourth, and the 17th amendments, though they abridge the scope of fundamental rights, on the basis of the earlier decisions, they were held to be valid. Now, this was the first time the doctrine of prospective overruling that was introduced by the Supreme Court. In short, 6 judges, they held that the view of Article 13(2) of the Constitution, in view of that Article 13(2), fundamental rights, they cannot be abridged or taken away. Whereas the other 5 judges, they held that 13(2), that was inapplicable to the acts amending the Constitution. Now, given this background, let us see what Kesavananda Bharati was all about. Now, this was a case which dealt with 6 petitions involving common questions as to the validity of the Constitution 24th Amendment Act, then the 25th Amendment Act, 26th and 29th. Of course, validity of the 26th Amendment Act of 1971, which was concerned with the abolition of privy purse, that was not considered. And it was left to be considered by another constitution bench. And of course, this was later decided by a 5 judges bench in Raghunath Rao versus Union of India, AR 1993, Supreme Court 1267. Now, to negate the effect of Golaknath, Parliament passed 24th Amendment Act, seeking to supersede Golaknath. Article 13 gets amended, wherein a clause is added, declaring that Article 13 shall not apply to any constitutional amendment which is made under Article 368. Likewise, a clause is added to Article 368, declaring that Article 13 will not apply to the amendment made under Article 368. Now, the marginal note of Article 368, that gets changed. Earlier, it was procedure for amendment to the Constitution. That gets changed to the power of Parliament to amend the Constitution and procedure thereof. And furthermore, there was a non-obstante clause which also was added to Article 368. And this clause suggested that the Parliament had the power to amend any part of the Constitution, including the fundamental rights. Now, that's all about 24th. 25th Amendment Act, that adds Article 31C, and it amended Articles 31 and 39 of the Constitution. Now, first it amended Article 31 Clause 2 and provided that anyone's property can be acquired on payment of an amount, the word not the compensation, of an amount. Secondly, it inserts Article 31C, which provides that if a law is passed to give effect to directive principles of state policy under Articles 39B or C, now the various fundamental rights which are set out in Articles 14, 19 and 31, all of them would cease to apply. Now, this Article 31C was almost like an absolute outrage on the Constitution, because it contained some sort of inbuilt mechanism to disband the true democratic setup which we had. And it really was meant to throw the rule of law overboard. Now, the 29th Amendment, that relates to the insertion of the Kerala Land Reforms Amendment Act of 1969, as well as the Land Reforms Amendment Act of 1971, which were put in the 9th schedule. And of the 6 repetitions, the one filed by Kesavananda Bharati, that was a lead case. Now, Kesavananda Bharati, as you all know, he was a Hindu monk who was a seer of a monastery by name Etnir Mud in Kasaragod district in Kerala. Now, the date has some relevance. That's why I am adverting to the dates. On 21st March 1970, Kesavananda, he seeks to enforce his fundamental rights under Articles 14, 19, 1F, 25, 26, and 31. Prays to declare the provisions of the Kerala Land Reforms Act of 63 as amended by the Amendment Act of 1969 as unconstitutional, ultra vires, and void. Now, interestingly, when this repetition was pending, the Second Amendment Act of 1971, that was passed. Kesavananda seeks permission to urge additional grounds and to impugn its constitutional validity. Now, as we all know, if you go in detail in the judgment, the theory of basic structure, that was not supported by any precedent or judgment of any court. And the said theory, that in fact was the brainchild of a German scholar, Professor Conrad, Dietrich Conrad, who propounded the theory of implied limitation based on the experience of Germany and the misuse of the Weimar Constitution by Adolf Hitler. And overruling Golaknath, the Supreme Court upheld the Constitution 24th Amendment Act entirely. First and second parts of the 25th Amendment Act found to be intra vires and ultra vires respectively. And it was observed by the court in relation to the powers of the Parliament to amend the Constitution, because that question was left unanswered in Golaknath. And the court goes on to hold that the Parliament could not use its amending power under 368. The court uses several words, either to destroy, damage, emasculate, abrogate, change, or alter the basic structure or the framework of the Constitution. And the basic features of the Constitution, according to this landmark verdict, it were laid out separately by each judge based on what he thought was the basic or the essential feature of the Constitution. And each of the judges in the majority, they explained their notions of what the basic structure was. I'll come to that. Justice Khanna, whose decision was the decisive factor insofar as the concept of basic structure and the amendability of the Constitution was concerned, he opined implied restrictions on the amending power, as well as the supremacy of the fundamental rights above all. They were the basic features of the Constitution. And he held that the word amendment meant to change or alter, and it could not mean completely defacing or abrogating a particular document. And it is this rationale which later on becomes the backbone on which the basic structure doctrine was formulated. Now, I would only advert to the majority judgments in detail for paucity of time. Chief Justice Sikri, his judgment was that Golaknath, though declared that a constitutional amendment that would be bad if it infringed Article 13(2), as it applied not only to ordinary legislation, but also to an amendment of the Constitution, it did not decide whether Article 13(2) can be amended under Article 368, or it did not determine the exact meaning of the expression amendment of this Constitution, which you see in Article 368. And he goes on to hold that the fundamental importance of the freedom of the individual that has to be preserved for all the times to come, and it could not be amended out of existence. Now, according to him, the fundamental rights which are conferred by way of Part 3 cannot be abrogated, though a reasonable abridgment of those rights, of course, could be effected in public interest. And there is a limitation on the power of amendment by necessary implication, acceptable implication, which was apparent from a reading of the preamble. And therefore, according to the learned Chief Justice, the expression amendment of this Constitution, which you see in Article 368, that was meant for any addition or a change in any of the provisions of the Constitution within the broad contours of the preamble, made in order to carry out the basic objectives of the Constitution. And that the said expression that does not enable the Parliament to abrogate or take away the fundamental rights, or to completely change the fundamental features of the Constitution, to destroy its very identity. And accordingly, every provision of the Constitution was open to amendment, provided the basic foundation or structure of the Constitution was not damaged or it was not destroyed. And he goes on to hold that Article 368 does not enable the Parliament in its constituent capacity to delegate its function of amending the Constitution to another legislature or to itself in its ordinary legislative capacity. And of course, as I already said, 24th Amendment upheld, Section 2 of 25th Amendment also upheld, Section 3 thereof, it was void as it delegates the power to the legislatures, state legislatures, to amend the Constitution, and also declaring the 29th Amendment indefective to protect the impugned acts if they abrogate or take away the fundamental rights. And of course, stating that the Constitution bench will decide whether the impugned acts that will take away the fundamental rights or only abridge them at a later point of time, whether they effect reasonable abridgments in public interest. The second judgment of the majority was that of Justice Chella for himself and Justice Grover. It was held that the preamble to the Constitution that contains the clue to the fundamentals of the Constitution, according to which Parts 3 and Part 4, which embody the fundamental rights and the directive principles of state policy, they have to be balanced, they have to be harmonized. And the balance and harmony between two integral parts of the Constitution, that forms a basic element, which cannot be altered. And the word amendment, which we see in Article 368, must therefore be construed in such a manner as to reserve the power of the Parliament to amend the Constitution, but not as to result in damaging or destroying the structure and the identity of the Constitution. So there was some sort of implied limitation in the amending power, which precludes the Parliament from abrogating or changing the very identity of the Constitution, or in taking away its basic features. And of course, validity of the 24th Amendment Act and Section 2 of the 25th Amendment Act upheld. Section 3, which introduced Article 31C, that was held to be unconstitutional and invalid for two vices. For two vices. Am I audible?
Yes. Yes.
Okay. So I was at
Yes,
section,
yes.
Article 31C. Now 31C, it was held to be unconstitutional. The two vices which you pointed out, the first was that it enables abrogation of the basic elements of the Constitution in as much as the fundamental rights which we see in Articles 14, 19 and 31 can be completely taken away. And the second being the power of amendment which you see in 368, that is of a special nature which has been exclusively conferred on the Parliament, and it can be exercised only in the manner which is laid down in that article, and the same cannot be delegated to any other legislature in the country. And the 29th Amendment also was held to be valid, again leaving open the question whether those acts included in the 9th schedule, whether those acts abrogate or any of the basic elements of the constitutional structure or denudes them of their identity. All those matters have to be examined at a later point of time when the validity of those acts would come up for consideration. Third judgment, Justice Hegde speaks for himself and Justice Mukherjee. Now the judgment goes on to say that the Constitution, which is essentially a social rather than a political document, it is founded on a social philosophy. And they point out it has two main features, namely basic and circumstantial. Now the basic constituent, that remains constant, no change. The circumstantial one, that was subject to change. Very interesting. Now, Justice Hegde, he held that the power to amend the Constitution under 368, as it stood before the amendment, that empowered the Parliament by following the form and manner which was laid down in that article. Of course, to amend each and every article or each or every part of the Constitution, and that the expression law in Article 13(2), even before 13 was amended by the 24th Amendment, it did not include amendments to the Constitution. It was held that though the power to amend the Constitution under Article 368, that of course was a very wide power, it does not include the power to destroy or emasculate the basic elements or the fundamental features of the Constitution. And of course, 24th Amendment held valid. According to the learned judges, the broad contours of the basic elements and the fundamental features, they were seen delineated in the preamble, and the Parliament had absolutely no power to abrogate or emasculate those basic elements or the fundamental features. And the building of a welfare state, the learned judges, they held, that is the ultimate goal of every government. But it cannot mean that to build a welfare state, human freedoms have to suffer a total destruction. Now, applying these tests, they invalidates Article 31C, even in its unamended form. And the 29th Amendment, of course, held to be valid. Again, leaving open the question whether the acts which were included in the 9th schedule, they abrogate or not the essential features of the Constitution. It has to be examined when the validity of those acts were gone into. So these three judgments constitute the view of 5 judges. Now the 6th judge was Justice Jagan Mohan Reddy. Now he held that the word amendment which was used in the sense of permitting a change in contradistinction with destruction, which the repeal or abrogation brings about. Therefore, the width of the power of amendment, that could not be enlarged by amending the amending power itself. And the learned judge, he held that the essential elements or the basic structure of the Constitution, they are reflected in the preamble, and that some of the most important features of the Constitution are justice, freedom of expression, and equality of status and of opportunity. And the word amendment, it could not possibly embrace the right to abrogate the very pivotal features and the fundamental freedoms. And therefore, that part of the basic structure, that could not be damaged, that cannot be destroyed. And according to him, amendment under Article 368, it does not include repeal, and the Parliament could amend the articles, even 13 and 368, and also all the fundamental rights. And though the power of amendment was very, very wide, it is not wide enough to totally abrogate or emasculate or damage any of the fundamental rights or the essential elements in the basic structure of the Constitution, or destroying the very identity. Again, 24th Amendment upheld the validity. Now, Section 2 of the 25th Amendment upheld, according to the learned judge. Now, regarding Article 31C, as it stood then, conferring the power of the Parliament and the state legislatures to enact the laws to give effect to the principles which we see under clauses B and C of Article 39, they altogether abrogated the right which you see guaranteed under Article 14 and were for that particular reason invalid. And of course, after severing such part, it can remain operative and effective. So holding Section 3 of the 25th Amendment valid. 29th Amendment also held to be valid. Again, leaving open the other question to be examined when the validity of those acts are under challenge. Now comes the odd man out, Justice H.R. Khanna, the seventh judge, broadly agreeing with these views of 6 learned judges. Broadly agreeing in some sense. I would just come to that a bit later. The 6 judges which I earlier referred to. And he held that the word amendment, which you see in the Constitution, that has to survive, because the Constitution has to survive. How to survive? Without losing the identity, which meant that the basic structure or the framework of the Constitution, that must survive any amendment made to the Constitution. And according to him, Article 368 contains not only the procedure for amendment of the Constitution, but it equally confers the power of amending the Constitution. And although it was perfectly permissible for the Parliament, in exercise of the amending power, to effect the changes so as to meet the requirements of the changing conditions, it was not permissible to touch the very foundation or to alter the basic institutional pattern which you see. So the word amendment of the Constitution, in spite of the whole width of their sweep and in spite of its amplitude, it could not have the effect of empowering the Parliament to destroy or abrogate the basic structure or the framework of the Constitution. So the power under Article 368, it neither includes the power to abrogate the Constitution, nor does it include the power to alter the basic structure or framework. And subject to retention of this basic structure or framework of the Constitution, the power of amendment, of course, is plenary, and it includes within itself, of course, the power to amend all the various articles, including those relating to fundamental rights, as well as, because even it relates to essential features, but with a caveat. No part of a fundamental right can claim immunity from the amendatory process by being described as the essence or core of that right. Because the power to amend, it also includes within itself the power to add, alter, or repeal various articles. And the learned judge, he also held that the word law in Article 13, Clause 2, that does not include the amendment of the Constitution and has reference to an ordinary piece of legislation, which in view of the definition contained in Clause A of Article 13, Clause 3, includes an ordinance, bylaw, rule, regulation, notification, usage, or custom within the territory of India having the force of law. And apart from the belt of the preamble, which relates to the basic structure or the framework of the Constitution, the preamble too does not restrict the power of amendment. So he also upheld 24th Amendment and the amendment in Article 31 and the first part of 31C introduced by the 25th Amendment held to be valid. Second part of 31C held to be invalid because in his opinion that contained the seed of national disintegration. He held that the second part of 31C that can be severed from the remaining part of 31C. and its invalidity that would not affect the validity of the remaining part. Now, the 29th amendment also, of course, held to be valid. So this is the detail of the 7 judgments by the 7 judges. Now, regarding the minority, I would just gloss over through the gist. The minority, it was that the power to amendment was unlimited. Now, on a construction of 31(2), as altered by the 25th amendment, now the state's right to acquire or requisition the property on payment of an amount, it must be so exercised that the amount it is not illusory or it does not constitute a fraud upon the right to property. And according to them, 31C was valid, even though it damages or destroys the essential features of the Constitution. So in short, 6 learned judges held that fundamental rights were unamendable, and there was some implied limitation on the power of Parliament to amend. Other 6 learned judges held that the Parliament had the power to amend each and every article of the Constitution, and the odd man out, as I said, Justice H.R. Khanna. Now he held power of amendment is limited, does not enable the Parliament to alter the basic structure of the framework of the Constitution. The substantive provision of Article 31C, which abrogates a fundamental right, is valid on the ground that it does not alter the basic structure or framework of the Constitution. But only the latter part of 31C, which ousts the jurisdiction of the court, that alone is invalid. And he held that the implied limitation on the power to amend, that was in relation to the basic structure of the Constitution. And this opinion of his, that becomes law. Now, briefly put, the majority view, which we see in Kesavananda Bharati, is that Golaknath gets overruled. And kindly see, 24th Amendment, sections 2A, 2B, and first part of section 3 of the 25th Amendment, 29th Amendment, all held to be valid. The second part of the amendment, which said that no law containing a declaration that it is for giving effect to such policy shall be called into question in any court on the ground that it does not give effect to such policy. That alone was held to be invalid. So, this was the crux of the Kesavananda Bharati judgment. Now, after this judgment was read out by the Chief Justice, now a majority opinion was circulated, which we see. I have already shared the PDF file. Now, the law declared by the Supreme Court is seen in that majority opinion. It was sent for circulation, for signatures. Now, 4 of the dissenting judges, Justice Ray, Justice Matthew, Justice Beg, and Justice Dwivedi, they did not sign the order. And virtually, the summary in this judgment, it is signed only by 9 out of 13 judges, which we see beautifully explained by Justice Y.V. Chandrachud in Minerva Mills, 1980, Volume 3, SCC 172, who spoke for the majority of the Constitutional Bench. Now, the second point in the summary that reads that according to the majority, Article 368 does not enable the Parliament to alter the basic structure or framework of the Constitution. And Justice Chandrachud observes that whether or not the summary is a legitimate part of the judgment, or whether it is per incuriam for scholarly reasons cited by the authors, it is undeniable that it correctly reflects the majority view. Now, in the same judgment, Justice Bhagwati, which you could see, Justice Bhagwati's judgment in this Minerva Mills, that was a common judgment in Minerva Mills as well as in Vaman Rao. Vaman Rao is a AR 1981 Supreme Court 271. And he opined that once the judgment was delivered, all the 9 judges, as also the remaining judges, they would become punctus officio. And therefore, they had no authority to cull out the ratio of the judgments. And he said, on a proper analysis of the judgments, what was the majority, it has to be found out by a later bench where the issue was raised. That task has to be undertaken by a subsequent court before whom such question would later arise. What was the law which was laid down in Kesavananda Bharati? But of course, even then we see there is a stamp of approval of the basic structure doctrine in Indira Gandhi versus Rajnarayan AR 1975 Supreme Court 2299. I shall add to that judgment within a few minutes. Now, the book written by senior advocate T.R. Andyarjuna. It is titled as the Kesavananda Bharati case, the untold story of struggle for supremacy by the Supreme Court and Parliament. That, of course, gives a very historical account of how this basic structure doctrine has been evolved in our constitutional law. And according to him, if you analyze Kesavananda Bharati, there is no majority for the implied limitation on the amending power. As Justice Khanna, he rejected the implied limitations on the Constitution. And to find out the ratio of this judgment, it is an absolute uphill task. For whatever reason and method the majority view was arrived, the axiom of unamendability of the basic structure of the Constitution, that has had a salutary check and control on the amending power. Now we see Chief Justice Sikri and Justice Shelab, they were in the majority of Golaknath, with the then Chief Justice Subbarao, who penned the majority view. So in effect, their views were sought to be reviewed or revisited in Kesavananda Bharati. Then the question would naturally arise, did not judicial propriety require both Chief Justice Sikri and Justice Shelab to recuse themselves because they were a part of the majority judges in Golaknath? If you read Justice Chandrachud judgment, of course, even before that, I would come to another aspect. Justice Chandrachud, he had openly told that he signed that majority note merely to accommodate Chief Justice Sikri. And the author of this book, senior advocate T.R. Andyarjuna, he points out that the then government was in possession of some of the draft judgments even before they were delivered. Now, the government decided on the supersession of judges even before the judgment was delivered in open court. That was decided. Of course, let me keep my hands off from that. Anyhow, it needs to be noted that the doctrine of basic structure, which is formulated by the Supreme Court in Kesavananda Bharati, that represents the highest order of judicial creativity. And of course, by a sharp cleavage of 7:6, the court held that the Parliament could amend any provision to fulfill its socio-economic obligation, which is guaranteed to the citizens under the preamble, subject to the condition that please don't change or alter the basic structure, because those are inviolable. And the court held that fundamental principles like what you see, federalism, secularism, then democracy, supremacy of the Constitution, separation of powers, they are all parts of basic structure. And any amendment affecting the fundamental rights in Part 3, that will be subject to judicial review. And this judgment is also an authority for the proposition that the Constituent Assembly debates can be looked into by the court while construing the constitutional provisions. The reliance was placed upon two judgments. One was the Travancore Cochin judgment, AER 1952 Supreme Court 366. And the second was, of course, Madhav Rao Sindhya, the Privy Council judgment, Madhav Rao Sindhya versus Union of India, 71-1 SCC 85. And of course, H.S. Dillon also is there. H.S. Dillon is 71-2 SCC 779. All these judgments held that the court, if it's a constitutional matter, then what were the intent of the framers of the Constitution, as you see embodied in the written document, that has to be ascertained. You should look into the proceedings, the relevant data, including any speech or debates, which possibly could shed some light on ascertaining that. And of course, you can reject if they are helpful, unhelpful, or if they do not throw some light, or it would throw only dim light, in which nothing can be discerned. Now, another important facet was the one regarding the power of judicial review. Now, judicial review, that power according to that court, that was of paramount importance in a federal constitution. The reliance was placed mainly upon two decisions. One was the BD Supply decision, which is AR 1956 Supreme Court 479, and the famous VGRO case, AR 1952 Supreme Court 196. These judgments also declare the separation of powers. That also is to be essentially a part of the basic structure of the Constitution, which doctrine has been reinvented in the modern times. And while mentioning this BD supply decision, we have to remind ourselves the famous words of Justice Vivian Bose, who in his concurring judgment to that particular judgment, he held that the Constitution was not for the exclusive benefit of the governments and the states. It is not only for the lawyers and politicians and officials who are highly placed. It exists for the common man, for the poor, the humble, for those who have businesses at stake, and the famous words, for the butcher, the baker, and the candlestick maker. Now back to the topic. If we digress, Article 368, which deals with the power to amend, that was, of course, draft Article 304 of the draft Constitution. Now I could lay my hands on the Constituent Assembly debates, which were held on 17th of September 1949 regarding this article. And it reflects that the members of the Constituent Assembly, they have given great emphasis on the constitutional dynamics while making this amending part. Dr. P.S. Deshmukh, who was in fact the first Union Minister for Agriculture in the first cabinet, he proposed an amendment by inserting Article 304A, which spelled that notwithstanding anything contained in this Constitution to the contrary, no amendment which is calculated to infringe or restrict or diminish the scope of any individual rights, any rights of a person or persons with respect to the property or otherwise, that may be permissible under the Constitution, and any such amendment which is or is likely to have such an effect, it shall be void and ultra vires of any legislature. Now, this was a proposed insertion of 304A. Of course, it didn't even see the light of the day. Now, Sajjan Singh, coming back to Sajjan Singh, Chief Justice Gajendra Gadkar, he of course retold the untrammeled power of the Parliament under Article 368, endorsing the view in Shankari Prasad. But a close reading of the judgment in Sajjan Singh, the penultimate para of the judgment of Gajendra Gadkar, Chief Justice Gajendra Gadkar, he observes that the Parliament may consider whether it would be expedient, whether it would be reasonable to include the provisions of Part 3 in the proviso to Article 368. And that is not easy to appreciate why the Constitution makers did not include the said provisions in the proviso when Article 368 was adopted. He stopped there, they didn't go beyond that. Justice Hidayatullah, he went further. He did not stop there. He stated that the Constitution gives so many assurances in Part 3, and it would be difficult to think that they were all playthings of a special majority. See the word he used, playthings. And then comes the classic judgment of Justice Mudolkar. True, he upheld the 17th Amendment, but he articulated his concern absolutely eloquently. He pointed out Article 368 was to amend the Constitution, but to what extent could such power be exercised? He illustrated his point by stating that as long as the words sovereign democratic republic are there, could the Constitution be amended so as to depart from the democratic form of the government or its republican character? If that cannot be done, then as long as the words justice, social, economic, and political, etc., if they are there, could any of the rights enumerated under Articles 14 to 19, 21, 25, 31, and 32 be taken away? If they cannot, it will be for consideration whether they can be modified. And see the eloquence with which this brilliant judge has concluded. Now, he held that the preamble to our Constitution that was drafted with deep deliberation, and it was marked by precision. And it was this decision of Justice Mudolkar that was the seed which germinated and blossomed as the basic structure doctrine we now see. And it would not be out of place to mention that Justice Mudalkar in Sajjan Singh, he referred to the essential features of the Constitution derived from the Supreme Court of Pakistan in a 1963 judgment of Faslul Khader Chowdhury's case, which was authored by the famous Chief Justice Alvin Robert Cornelius. And this has become a great contribution to our Constitution from across the border. And having said this, the aftermath of Kesavananda Bharati, that also is quite interesting. As we know, from 50 to 73, virtually no attempt was made by the political executive to undermine or influence or dominate the judiciary. Nehru, Gulzarlal Nanda, Lal Bahadur Shastri, and Indira Gandhi, they were running the show up to 73. Then certain things could not be digested by the political executive leadership, which included, one was the Privy Council case, the Privy Purses case, which, of course, it was by an executive fiat that was invalidated by the Supreme Court, 11 judges bench, Madhavrao Scindia case, which I have referred to earlier, where majority of 9:2. You had R.C. Cooper, and finally the Kesavananda Bharati judgment. Now, as a sequel to these judgments, now the executive reacts. Immediately after the Kesavananda Bharati judgment, Mrs. Gandhi retaliated. Of the 7 judges who delivered the majority, Chief Justice Sikri, he retired on the next day of delivering the judgment. That's on 25th of April, 1973. The 3 senior most judges, Justice Shelat, Grover, and Hegde, they got superseded. Justice Ray becomes the new Chief Justice. Then, after 2 years, on 25th of June, 1975, the emergency was declared. That continues till 21st of March, 1977, during which period the second supersession takes place. That was on 29th of January, 1977. Amidst this, Justice Mukherjee, he died in harness. Justice Jagan Mohan Reddy retires in due course. And the sole man left, Justice H.R. Khanna, the last continuing judge. He was forced to resign after being superseded for this Chief Justiceship. And upon the retirement of Justice Ray, Justice Beg becomes the Chief Justice. And during the emergency, by way of constitutional amendments, the power of judicial review, which was vested in the higher judiciary, that was sought to be undermined. Now, the intrusion during the emergency that came to be remedied later when the Janata Party came to power, as we know through the 43rd and 44th Amendment Acts, which restored the position of judicial review to its original position, as was provided by the Constituent Assembly earlier. Now, there was a very serious attempt to overrule this Kesavananda judgment by another 13 judges. After the Allahabad High Court annulled Mrs. Gandhi's election on the ground of electoral malpractice, she obtains a stay from the Supreme Court. And then the president, on the aid and advice of the government, declares an emergency. Now, Mrs. Gandhi, she bestrode the political landscape like an avenger. Government passes the 39th Amendment Act, which contained 3 principal features. First, Article 71, substituted by a new Article 71, which stated that subject to the provisions of the Constitution, Parliament may by law regulate any matter relating to or connected with the election of a president or vice president, including the grounds for which such election may be questioned. Second feature, inserting Article 329A, that contains 6 clauses. Third feature, in the 9th schedule to the Constitution, after entry 86, just before the explanation, entries 87 to 124, both inclusive, they were inserted. Of course, the Representation of People's Act of 51, the Amendment Act thereto of 74, and of course the Election Laws Amendment Act of 75. They were all mentioned in this entry 75. And the amendment that rendered all pending proceedings before the courts regarding the elections as null and void. So kindly see, this amendment in fact made the Allahabad High Court's verdict and its appeal before the Supreme Court non-est. Now, this amendment was a subject matter of a challenge in Indira Gandhi versus Raj Narayan, which I referred earlier, AR 1975 Supreme Court 2299. And the 5 judges Constitution bench struck down the 39th Amendment Act using the basic structure doctrine which is propounded by Kesavananda Bharati. Now, kindly see, very interesting to note that the 5-judge bench considered, 5-judge bench, it was constituted by Chief Justice Ray, then Justices H.R. Khanna, Justice Matthew, Justice Beg, and Justice Chandrachud. 4 of whom were on the minority in Kesavananda. They did not subscribe to the basic structure doctrine in Kesavananda Bharati. But in this case, each one of these minority judges, they struck down 39th Amendment Act, accepting the argument that it destroys, that it damages the basic feature, the basic structure of the Constitution. And after a couple of days of the decision, Chief Justice Ray, he convenes a special bench of 13 judges. He wanted to review the Kesavananda Bharati. Stage was all set. Arguments went on for 2 days, 10th and 11th of November 1975. And nobody knew how this bench was constituted because 8 out of 13 judges, they were new and they were not part of the bench in Kesavananda. Again, Nani Palkiwala, he vociferously argues before the 13 judges for 2 continuous days, defending Kesavananda Bharati. And during the hearing, there was a query as to how this bench came to be constituted. To which Chief Justice Ray, he looked at Palkiwala and said, "You requested." No, Palkiwala, decrying it as utterly absurd, he asked, why would he challenge a decision in his favor? Then Justice Ray stated that the state of Tamil Nadu sought for a review, to which the Advocate General of Tamil Nadu, at that point of time, Govind Swaminathan, he responded that the state stand by the judgment in Kesavananda. Similar response from the Advocate General of State of Gujarat. And the exchange made the other judges realize that this is a bench which was constituted at the behest of Justice Ray himself, who arguably wanted the decision Kesavananda Bharati to be overruled. And on the 3rd day, Chief Justice Ray, he comes to the courtroom and simply announced bench dissolved. And he walked out. And very interesting to note that there was no written application or a review petition which was filed before the Supreme Court. And normally, the Supreme Court does not hear review petitions in open court. Now, as we see, Kesavananda, it held that the Constitution is supreme. And all organs, the legislature, the executive, judiciary, they all owe their existence to the Constitution. And each organ, they have to function within the four corners of the constitutional provisions. And the doctrine of parliamentary sovereignty, as it is in England, it does not prevail in India, except to the extent which is provided by the Constitution. And of course, the judiciary is interested with the task of construing the provisions of the Constitution to safeguard the fundamental rights. And the parliamentary democracy in India, that is distinct from what we see in England, from where we have borrowed this Westminster model of government. And of course, the Constitution, that is the supreme lex of this country. And it is beyond the pale of any controversy. Now, this includes the court also, which represents a judicial organ. I leave the sentence there. Now, the principle of supremacy of Constitution that was reiterated in various judgments. I have already said about the Minerva Mills case, the Indira Nehru versus Raj Narayan, Minerva Mills. Subsequently, a lot of decisions are there, like Manilal Singh. You have the Gujarat Assembly elections case, the PUCL versus Union of India of 2003. You have Pratap Singh, Rameshwar Prasad, Kuldeep Nair, ever so many judgments. Now, in Indira Gandhi versus Raj Narayan, I just forgot one thing. The Justice Khanna, he clarified his view in Kesavananda Bharati in this particular judgment. Now, he clarifies that the Parliament, in exercise of its power to amend the Constitution, of course, it cannot destroy or abrogate the basic structure. And no distinction was made in regard to the scope of the amending power relating to the provisions of the fundamental rights, and in respect of the matters other than the fundamental rights. And the limitation which is inherent in the word amendment, according to which it is not permissible by the amendment to change the basic structure, it was to operate equally on articles pertaining to fundamental rights as on the other articles which were not pertaining to any of those rights. And Justice Khanna noted that the right to property was held by him not to be a part of the basic structure. He really clarified. And just before I conclude, a few more words on Kesavananda Bharati, that what we understand from this judgment is that our constitution, we should not see it as merely as a document which is written in ink to replace one legal regime by another. Now it's a testament which is created for securing the goals which you see professed in the preamble, which is the soul of the constitution. And so while interpreting any provision of the constitution or examining any constitutional issue, or while determining the width or reach of any of the provision, or when any ambiguity or obscurity it is noticed in any of the provision which needs to be clarified, or of course when the language would admit of more meanings than one, then of course the preamble has to be relied. Because as a remedy for the mischief, so as to find out what is the true meaning of the relevant provision, as the case may be. And the judgment of Justice H.R. Khanna explains how the constitution should be read and interpreted. Kindly read para 1437, where he goes on to quote the great American jurist Oliver Wendell Holmes, who, while dealing with the US Constitution in the case of Samuel Gompers, a 1914 decision, stating that the provisions of the Constitution, they are not mathematical formulae having their essence in their form. They are organic living institutions transplanted from English soil. And he also recalls the United States Supreme Court's fourth Chief Justice, John Marshall, who was the founding father of the US constitutional law, who during 1819, in the famous McCulloch versus Maryland, he said that it's the constitution we are expounding. And kindly see para 2065 of Kesavananda. Justice Chandrachud, the first paragraph, he states that the council, they consume so much time to explain their respective points, and the very little time was left for the judges to elucidate theirs, and that the time factor threatened at one stage to assume proportion as grave as the issues which arose in the case. And he goes on to observe that the court, very sooner it would be poorer by the retirement of the learned Chief Justice, and a dateline was set for the judgment, and that there had not been enough time for him, even after conclusion of the arguments, for an exchange of the draft judgments among the judges. And he had the benefit of knowing fully only the views of 4 judges. Another aspect of relevance was the minority view of Justice K.K. Matthew. An absolutely brilliant piece of judgment. Now, Justice Matthew endorses the minority view of Justice Hidayatullah in Naresh Sridhar Mirajkar, AR 1967, Supreme Court, page 1. It's a 9-judges bench decision, which held that judiciary is state within the meaning of Article 12. Of course, it was in minority. Now, Justice Matthew again reiterates this in the 7-judges bench decision in State of Kerala versus N.M. Thomas, 76, AR 1976, Supreme Court 490, where his view was the majority view, even though it was given separately. And even though the doctrine of this basic structure that evolved in Kesavananda, the case never laid down any particular features or specific features you cannot see in the judgment. As we could see, Nani Palkiwala, he argued 12 essential features, which we see delineated only at para 919 in the judgment of Justice Ray alone. In no other 10 judgments, it is spelled out. 12 essential features, they were argued by Nani Palkiwala, which is reproduced only in the judgment of Justice Ray. And of course, in the judgments of Justice Shelat, Hegde, Justice Jagan Mohan Reddy, of course, there are specific observations to the effect that their list of essential features comprising of the basic structures, they are illustrative. They are not intended to be exhaustive. And following Kesavananda, there has been a long line of decisions which has characterized certain things as basic features, which we saw right from Indira Gandhi versus Rajnarayan, that is the free and fair elections. Minerva Mills, the fundamental rights as well as the directive principles of state policy. You have the judicial review in SP Sambat Kumar. It was first in SP Sambat Kumar, AR 1987, Supreme Court 386, and then it was reaffirmed by a 7 judges bench in Chandra Kumar, 97 3 SCC 261. Then unity and integrity, which we see in Raghunath Rao, the Privy Council, and so on. Even Shamsher Singh, the 7 judges bench in Shamsher Singh, independence of judiciary, it was first held in Shamsher Singh, AR 1974, Supreme Court 2182, approved in the 9 judges bench, which we popularly know as the second judges case, 93 4 SCC 441, reaffirmed in another 9 judges bench, the third judges case, AR 1999, Supreme Court page 1, and of course in the NJSC judgment 2016 5 SCC 808, where Justice Kurian Joseph was a party, and he had an occasion to even say that if Shamsher Singh was properly adverted to in SP Gupta, there would not have been a need for the second judges case. Then you see SR Bombay, 9 judges bench, parliamentary system, 94 Supreme Court 918, several judgments, many judgments. And I would just cite only one of the judgments, which is Jammu and Kashmir National Party, that is National Panthers Party, which is AR 2011 Supreme Court page 3, speaking through Justice Ganguly, held that though we must have a clear perception of what the basic structure is, it is hazardous to define what the basic structure of the Constitution as what is basic, because it cannot remain static for all times to come. And Justice Ganguly, he enlists around 2 dozens of basic features which he cults out from various judicial pronouncements. And a few months back, our former Chief Justice U.U. Lilith, in one of his lectures organized by the Kerala High Court Advocates Association, he stated that the Kesavananda judgment that has given us the fulcrum on which the entire jurisprudence of independence of judiciary has since then developed. Our present Chief Justice, D.Y. Chandrachud, when he delivers a lecture organized by the Nani Palkiwala Memorial Trust, he stated that the basic structure is like a North Star. It guides and gives us a certain direction to the interpreters and the implementers of the Constitution when the path ahead is convoluted. We have Justice B.V. Nagaratna, again another lecture which was organized by the Kerala Federation of Women Lawyers, where Justice Nagaratna stated that the Constitution of India that is stronger now because of the Kesavananda Bharati judgment. And it is the duty of all of us in the legal fraternity to go through that judgment and reassure ourselves on the impact that it has had on our country. And one of the most interesting facets is that Chief Justice Beg, in a 7 judges bench decision, which is State of Karnataka versus Union of India and another, it is 1977 4 SCC 608. In rather intriguing terms, he went on to hold that Kesavananda judgment, the Supreme Court did not work out the implications of the basic structure doctrine in its applications. And perhaps the word used was, it was left there in an amorphous state, which could give rise to possible misunderstandings as to whether it is not too vaguely stated or too loosely formulated, without attempting a basic uniformity of its meaning and implications. And of course, this doctrine, it has been explained in a recent decision of the Supreme Court, Janhid Abhiyan versus Union of India, is a 2022 decision, 2022 SCC online at page 1540, which of course considered the Constitution 103rd Amendment of 2019. With Justice Dinesh Maheshwari, he goes on to beautifully explain this doctrine at considerable length. And of course, I should not forget to mention IR Polo versus State of Tamil Nadu, 2007 2 SCC page 1, which also explains its basic structure at great length. And we need to be proud to note that the basic structure doctrine, which has been evolved through this Kesavananda case, that was adopted by the Supreme Court of Bangladesh in 1989 in Anwar Hussain Chowdhury's case, the Supreme Court of Belize in Barry and Bowen's case, then in 2009 by the Supreme Court of Uganda in Male Mabirisi's case, another historic 17 judges bench of the Pakistan Supreme Court in District Bar Association versus Federation of Pakistan, again in 2004 by the High Court of Kenya in Nijaya's case, and in 2011 by the Seychelles Court of Appeal in the Popular Democratic Movement case, and so on. Now, I could go on and on, but for the time constraint, now let me just wind up by saying that the 13 judges bench, which was split right down the middle at 6:6, until the legendary Justice H.R. Khanna, he stepped in and lent his support to this basic structure doctrine. And thus, the Indian democracy that was saved by a very wafer-thin margin of 7:6. And of course, as we see, Kesavananda, the seer who really saved the constitution, he literally lost the case. Though this judgment, illustrious judgment, it has given birth to the basic structure doctrine, which introduced a major check to the power of the parliament to make drastic changes to the core values of the constitution. And I would say, but for this great judgment and the great jurist Nani Palkiwala, as he argued, could it have culminated in the devastation of the very foundations of our democratic polity and led down the slippery slope to dictatorship? And I would conclude merely by referring Chief Justice Kapadia's opening words in Glenrock Estates case, 2010, Volume 10, SCC 96, that some doctrines die hard, and that certainly is true of the doctrine of basic structure of the Constitution. Thank you so much for your patient listening.
Yes.
Prem, wonderfully encapsulated. I mean, that 780 pages, maybe the time was, not sufficient or whatever it is. I mean, wonderful.
I just ran through.
Yeah. Please.
It is a wonderful day. I realize that as a student of law, it was, coming back again to the table of learning with all of you, Honorable Justice Kurian Joseph, my lords, opened it. And of course, learned friends, Premji and Shyamji, they have been on to it. And they've been really working hard in this academic field, which we all have been given a platform to hear, learn, listen, assimilate, engage, and do everything that is possible regarding being a student of law. Honorable Justice Roshan Dalvi, Honorable Justice Seetharama, Honorable Justice Nagamuthu, Honorable Justice Rajive, Bhalla, Honorable Justice Anand, Venkatesh. It's a wonder. I am reminded of a story. All the such big luminaries around. Everything has been covered. I would not say much, but I would definitely tell a story which I heard. And the story was when the temple of the Tanjore were being made. Probably it was in the Chola dynasty, if I rightly recollect. And there was one Raja, Chola, Raja, Rajeshwar. If I'm not some name, maybe it's slightly here and there. So he went to inspect the making of the temple. So there was this mason cutting these stones. So he asked him, Mr. What are you doing? So he said, I'm cutting stone. He went to the second mason. He was also doing the same thing. And he said, what are you doing? So he said, I'm earning livelihood for my family members. So he said, very good. He went to the third mason and asked him, what are you doing, mister? He was doing the same job. And he said, sir, I am creating a grand temple, a grand design. So probably while all in the law fraternity, all of us together are doing the same work, but it has to be the grand design which has to work, which has to function. And when I see all of us getting together and all of you, with preparing for such grand design, strengthening it, we have to keep assimilating, keep on re-engaging on these platforms to understand as law fraternity. As law fraternity, we are all students of law and we never stop learning. We have to keep on understanding that we are in the grand design of the Constitution, the grand design of the democracy, the grand design of this great country, humanity, the whole world. Now with the globalization happening, there are newer dimensions to everything. And Kesavananda Bharati, of course, is a grand contributor to the same. And I was on the same page when Premji was reading. As I was also seeing on that Kesavananda Bharati, His Holiness was amazed why my name is coming in the newspapers so often. I have not done anything that good or that bad. and he was worried about the whole litigation, and he never spoke to Consul Palkiwala or anybody, but still, I mean, he was amazed to see the attention that the case was getting, and many other amusing things which have been already shared. I always remember those words of Justice Matthews, which as a student of law, always they enthuse me. And those words are that every generation has to fill in the tumbler or the vessel, which is an empty vessel, where chapter 3, it is said regarding the chapter 3, Justice Matthews said that is like an empty vessel, and every generation will have to pour in their own understanding. So it is probably that effort has to continue. We all have to continue. Our next generation will come in, the next will come in, the next will, everybody has to keep pouring in. And while maintaining the understanding which we have derived and which we have gained from the past experience, we have to go ahead and make our way ahead. Kesavananda Bharati is also one such judgment which lays down the foundation as to how a long dilemma which continued from Shankari Prasad, Sajan Singh, Golaknath, and the great dimension. Even I always say that the travel of the legislature from 42nd Amendment to 44th Amendment itself shows that how the whole function, how there is a delicate balance in the constitution where legislature drops in wherever there is wherever it requires strengthening regarding the functioning of the constitution. So for the debate between 42nd and 44th Amendment, if we see the parliamentary debate, I read it. I mean, both these debates, this is the same line and length which is there with the judiciary, and how it has been contemplated by the legal system, and those great stalwarts like Palkiwala and Sirvai have gone in and threadbare tackled the whole issues. And it is not that all the 11 pieces, all the 11 scholarly pieces are worth reading for every student of law. I read every one of them just to understand it better. It was not that a perspective may change sometimes, but what will not change is that the scholarly inclusions that have come in, the dimensions that have been drawn there. Like, for example, I was just reading that the words of Justice H.R. Khanna, which, as Shyamji has rightly expressed, that he was the man who was doing it. I mean, Premji has rightly told us that he was the man who was doing it. He was the whole thing was at the boundary line, because all the judges, 13 judges were sitting. There were 2 retired judges who were brought in, and they were made to administer the Supreme Court justice system, while the special bench of 13 judges sat in this basic structure. And those 2 judges took care of the daily administration of justice even when they were retired. So this is wonderful. I mean, it is a wonderful experience. I think Kesavananda Bharati was unique. And those words which I was referring to was of Justice H.R. Khanna, which says, although it is permissible under the power of amendment to effect changes, however important, and to adapt the system to the requirements of changing conditions, it is not permissible to touch the foundation or to alter the basic institutional pattern. I mean, the manner in which they have dealt, each one of them, all those 11 judgments. And see, Justice Palekar, although it is a dissenting judgment, how interesting what he says. One cannot lift parts of constitution above it by ascribing ultra-constitutional virtues to them. So these are this was the contemplation that went in. It was not that simply they came into sat into a bench and arrived at a conclusion. It was one of the most thorough judgments which has been passed, and the assimilation that has taken place. One of the judges saying that you can't create an ultra-constitutional virtue. Another judge, Justice Beg, said the good of the mass of the citizens of his country is supreme in law. Yes, it is right. It's every one of them, all the 11 scholars. They wonderfully put it for the future students of law like me, and who have been able to understand it to some extent with the help of this judgment. Because all the perspectives have to be. I remember when once I was arguing Article 12, I remember that the judgment in Zee Telefilm, which was rendered as a dissenting judgment, that time was carrying so much of power and giving so much of amplitude to Article 12, that these are the kinds of things, whether even if it is dissenting in Zee, I'm talking about Zee Telefilm, and Justice Sinha's judgment was, Honorable Justice Sinha's judgment was dissenting. I mean, those sometimes dissenting judgments are wonderful to read and wonderful to understand as students of law. We all have our foundations when we are in our respective places in the legal fraternity, but certainly we need to gather more on such platforms for the grand design of the, as I said, the story which I just told. We have to all assimilate, and thank you, Premji, for such wonderful expressions. I mean, you really simplified it for all of us. I had studied that a complete thing, and so I was able to probably understand a bit better and go through everything. I mean, each one of them, I mean, it was wonderful. Each one of the 11 judges were wonderful. And the manner in which historically, and one thing which you said was right, the doctrine of prospective overruling. If there was no doctrine of prospective overruling, the whole thing would have turned it into a very, very tumultuous event. But yes, doctrine of prospective overruling gave it a shape where we had it for the future, but we did not destroy it for the past. So that was a very beautiful thing to happen. As a student of law, I see it as a very, very progressive understanding of the legal system at that time by the scholars who were there in the system on the both sides. Thank you very much. It was wonderful. And I'll continue to get, the other esteemed learned scholars are here. The grand design makers are here. So we'll continue to hear them. Thank you so much. Shyamji,
Thank you.
both of you, you are great. I mean, it's a great job. Thank you. Thank you.
Thank you, sir. Thank
Thank
you.
you, sir.
With Justice Roshan Dalvi's permission, ma'am, can I just request, because Justice Seetharama Murti and Anand Venkatesh sir said they wanted to leave. So I just request Seetharama Murti sir, please.
Once again, namaskar to all of you. Wonderful, sir. One single word, wonderful. Sir, one thing all the present-day youngsters have to learn from today's guest speaker is the habit of reading all judgments of the Supreme Court. Whatever be the subject the learned advocate is dealing with, I expect him to read all the judgments of the Supreme Court of the yesteryears. They help a lot in grooming an advocate. Nowadays, we find there are many youngsters coming from the law schools. No doubt they are doing very well. But a majority of the lawyers, say, for example, a civil lawyer is not reading thoroughly the CPC. We find a lot of dirt while cases are presented in the law courts. So I think the youngsters must emulate today's wonderful speaker. That is the first thing I wanted to make a mention. The second thing is, all judges are stalwarts and the lawyers equally good. And ultimately a wonderful product. And it left a legacy. And for a short time, I was not with all of you. Just I went out to refresh. I don't know whether the 10th schedule judgment, anti-defection law judgment was referred to or not. It is another landmark judgment. Shyamji, is it referred?
Sir?
Cogito.
No, sir.
No,
sir.
It was not referred.
It was not referred. Actually, that also was the.
Yeah,
It was the.
a good, very good judgment. It is one of the legacies of the Kesavananda Bharati.
True. Cogito is there.
Yeah. So, my humble view is that the Supreme Court is not supreme simply because it has the last word. Supreme Court is supreme only because it is having the last word. That is what the learned judges Supreme Court said already. So the journey goes on, and my assessment is from the judgments of the recent past of the Supreme Court, we are on the right track. We are on the right road. Wonderful, sir. Thank you for giving me an opportunity to participate and listen to your wonderful lecture. Thank you.
Thank you.
Thank you, sir.
Thank you very much. Now, Justice Anand Venkatesh, sir, now that you mentioned that you will have to leave, sir, please, over to you.
Good evening to all. I'm sorry that I'm trying to sort of overtake many of the speakers who are supposed to speak before me. Please pardon me for that. And thank you, Shyam, for giving me this chance. And as always, Premraj has already spoken everything about it. So it was so wonderful, meaning he was on a flow. So I thought he must be given his full say on whatever he wanted to expound on the Kesavananda Bharati case. I want to just touch upon 2-3 things and leave it to your thought. See, while overruling Golaknath, Kesavananda introduced a new concept of basic structure of constitution, while conceding to the parliament the power to amend. The court circumscribed that power by holding that it could not be exercised so as to alter the basic structure of the constitution. That's the long and short of Kesavananda. The court reserved to itself the right to adjudicate upon every future amendment of the constitution, whether it altered the basic structure or not. This is what the court had reserved to itself, that right that has been reserved to itself. The word which I want you to note is that the court reserved to itself the right to adjudicate every future amendment of the constitution, the constituent power, whether it altered the basic structure or not. But subsequently, a lot has happened. That's what I'm attempting to say here. Since there are no signposts signaling the basic features of the constitution, because each of who delivered the majority opinion had their own list of they thought to be the basic structure. Really discover the basic feature becomes a voyage discovery, in my view. And it's like there is no some indications in the constitution as to where you do it, because I said that is it something which is hovering over your head, which you will not be able to find at all. And of course, Justice Krishna said that when you are trying to trace it, you please trace it in the constitution itself. So to that extent, if you look at the constitution, you will be able to get indications about the basic structure from the preamble of the constitution. And as you all must be, the preamble was the last item in the debate of the Constituent Assembly. We must not be under the impression that that was the first one. That was the last one. That was the last thing which happened when they captured the entire constitution and said that this is the objective for which we have done all these things. If you look into the constitutional debates, you will find that. So the preamble is one portion which gives the indication as to what all can be construed as basic structure. Of course, 368 proviso itself gives some indication as to what all can be seen as a basic structure. As you know, wherever it touches the federalistic powers, wherever it touches the judiciary, etc., you will find in the proviso that it adds more difficulty to really amend those parts. And of course, over a period of time, judicial review is also now seen as a basic structure of the constitution. You will not get it anywhere, but then that was the one which was pronounced in, as you all must be knowing, in Chandrakumar's case. So the one criticism about Kesavananda Bharati always is that it was essentially one with a political background. That is the major criticism on Kesavananda. In his autobiography of Jaganmohan Reddy, Justice Jaganmohan Reddy, he says that I got an impression from the first day that minds were closed and views were determined. That's what he says in his autobiography. Andi Arjuna also recollects the one which was referred by our friend Premraj, that the bench was clearly divided and some judges were clearly in favor of the petitioners, and while others were on the opposite side. And right from the beginning, there was no doubt as to which side some judges are inclined. So that was how it was positioned even from day one. So the view of Andi Arjuna is that for him, the final verdict was a political one. And although the verdict eventually proved to be very useful, the manner in which, this is important, the manner in which the case was conducted and the judgment was delivered left much to be desired, is what he says. Of course, the product which came out of this judgment really saved this nation, as Premraj was attempting to say. And the two other things which I want to say is that I was emphasizing on this amendment of the Constitution, which was this basic structure doctrine was brought in through this judgment, only keeping in mind the amendment to be made in Constitution. And as you all must be knowing, that there is a constituent amendment and there is a legislative amendment, an ordinary amendment which takes place. For the first time, this basic structure doctrine got into such an act in Indira Gandhi versus Rajnarayan. So it is here where for the first time the question of applicability of the basic structure doctrine to ordinary laws arose. This is the first time it arose. It was never, if I please correct me if I am wrong, it was never intended when the judgment was passed in Kesavananda Bharati. The intention was to apply this doctrine only in an amendment in the Constitution. I do not know whether they really intended to apply it to the ordinary laws. But anyway, this was the first judgment where it was done. And here, if you look at the observation made by Justice Ray, he says that the ordinary laws shall not be subject to the test of basic structure, as by doing so, one would equate legislative measures with constitution amendments, is what he comments when this happens. So he even observes that this will mean rewriting the constitution and robbing the legislature of acting within the framework of the constitution. So this is something about which we have to mull over also. So applying the doctrine of basic structure to ordinary laws, it is thought that it would denude the power of the parliament and the state legislature of laying down legislative policies. And as you all must be knowing, after the judgment of R versus Kolho, that's that 2007 2 SEC page 1, that was the judgment which carved out an exception. That was one judgment where the law, where it dealt with two things. One is those laws that were inserted into 9th schedule. See, now basically we have three things. One is the amendment to the constitution. Second is the amendment, an ordinary law. And the third is the one which has been put into schedule 9. And this is exactly what was considered in that judgment. And they carved out an exception to the law that ordinary laws cannot be tested by the basic structure doctrine. And they held that the laws that have been inserted in the 9th schedule of the constitution have to be first tested for the violation of part 3 of the constitution, since article 13(2) has to be satisfied. Then if they fail to clear muster, such laws must be additionally tested for violation of basic structure doctrine. So only if they fail in both, such a law can be declared as unconstitutional, was the law that was pronounced in the judgment in Kolho. So, so basically, this extension of this basic structure doctrine into interpretation of regular laws, I think, was never intended when the in Kesavananda Bharati was pronounced. And the next thing which I want to say is that the latest judgment which I saw in this is Janhit Abhiyan versus Union of India. See, in that judgment, that was, all of you must be knowing that that's a judgment which concerns about the EWS quota, economically weaker section quota. There is a very interesting concurring judgment of Honorable Justice Parthivala. He says that he looks into the what Justice Khanna, like how Justice Hidayatullah was the person who tilted Golaknath. It is Khanna who tilted Kesavananda Bharati. And they always used to say that it is actually not 7:6. It is 6.7:6.3. that's how minutely they have gone into it and said that it is actually not 7:6. As we all are thinking, it is actually 6.7:6.3. It is to that extent, it's a shift. So if you look at it, the Khanna's judgment, if you read it, it will in, I don't want to really put it in the screen and do it. It will give you an impression at paragraph number 1473. I am referring from the SEC judgment, that is 1973, 4 SEC, page 225. Paragraph 1473 will give you a sort of understanding that he would say the argument that preamble creates an implied limitation on the power of amendment cannot be accepted unless it is shown that the Parliament, in compliance with the provisions of 368, is debarred from amending the preamble insofar as it relates to matters other than basic structure, and removing the supposed limitations which are said to be created by the preamble. So basically he says, I don't find an implied restriction or limitation insofar as the power of amendment is concerned. But he also says in paragraph 1508 that when it touches the basic structure, then to that extent it is limited. Meaning if you read the judgment of Justice Khanna, it may give you an impression that if there is no implied limitation, then it only means that amend is absolute. If there is an implied limitation, only then you can read base structure into it. So this was taken into consideration by Honorable Justice Pardiwala in this judgment. And he says, if you have the time, please read it. He says, thus it is very clear that the sense in which Justice Khanna uses the expression basic structure or framework of the Constitution is very different from the sense in which the 6 judges led by Sikri CJ used that expression. Essential features or basic features of the Constitution. Fundamental rights can be abrogated by the use of amending power according to Khanna J, but not so according to the 6 judges led by Sikri. You will find this observation made by Justice Pardiwala in that. So if that is what it is, then I think this what I said is that 6.7 and 6.3 itself gets tilted. But like how you have a codicil for a will, Khanna wrote a codicil in the subsequent judgment. So, meaning we all say that you will have to speak through your judgment, but Justice Khanna had the rare distinction of explaining what he intended in his earlier judgment. That was the judgment which our friend Premraj had noted in this. This is the judgment in just a minute.
Indira Gandhi versus Rajasthan.
Indira Gandhi, correct. In Indira Gandhi. Where you will find, I'll just give you the paragraph numbers also. You will find this explanation given by him in paragraphs 252 and 253. 252 and 253 paragraphs. He will say actually what he did in that judgment. So if you take that codicil and read it with the paragraphs in the main judgment in Kesavananda Bharati, then I think that 6.7 is to 6.3 is correct. But I do not know whether a judge can write a codicil for his judgment. And a judgment can always be read and understood only as to what has been presented. So this is yet another interesting facet which you will find. And finally, as Prem was saying, the basic structure doctrine subsequently taken over countries like Malaysia, Bangladesh, Uganda, Zambia, and in Pakistan, they were going back and forth. In Pakistan, they were going back and forth. And you must understand that it's very important to know what was happening in Pakistan, because they also got this constitution somewhere 1954 or so. And immediately thereafter in 1958, the president declared martial law and he installed Ayub Khan as the chief martial law administrator, and he dismissed all central and provincial cabinets. He abrogated the constitution, meaning the constitution was thrown to dustbin. Then this becomes a subject matter of challenge, and the judgment of Chief Justice Muhammad Munir in that is very, very, it's meaning it's mind-boggling. He takes the Kelson's theory of the legal positivism and he says, this is what he says. For the purposes of the doctrine herein explained, he says, if the revolution is victorious in the sense that the persons assuming power under the change can successfully require the inhabitants of the country to conform to the new regime, then the revolution itself becomes a law, creating fact, because thereafter its own legality is judged not by reference to the annulled constitution, but by reference to its own success. And this is what would have happened if we had not got into, if we have not really got hold of the basic structure doctrine. He says, fine, till revolution did not succeed, if you get caught, you will be treated under the law that is in force. If the revolution succeeds and constitution is thrown out, please don't refer to a constitution which is not there. And it is the revolution which will govern you. And this is an extreme situation, but this is what would have happened, probably something near that, if the Supreme Court had not evolved the basic structure doctrine. And Pakistan was going back and forth. And ultimately, when the Chief Justice was thrown out, Pakistan thought that hereafter we should take a chance. And 17 judges sat. Probably can never rule at all. So 17 judges sat. And this is that the famous judgment of District Bar Association versus Federation of Pakistan, where they touched upon basic structure doctrine. And finally, as you know, United Kingdom does not have a written constitution. It's an unwritten constitution. And please see this is one of the very revealing passages which I read in Jackson versus AG. I had sent it to Shyam Padman also, if you have it. And see what he says in that. As you all must be knowing, they examine whether the court could place any limitation on the principle of parliamentary sovereignty, which is a cardinal feature of UK's unwritten constitution. In two important passages, this is what the House of Lords are saying. Can you put it, Shyam?
Just 1 second, sir. There's some
Yes.
technical glitch. I'll try to.
Yes. I didn't want to waste all your time in showing what the other courts have said, but I thought that a country without a written constitution is saying this. It becomes very important for us to take note of that. And that was a country which was always looking at the theory of Kelson, the Grundnorm. Always have this pyramid, and the one which is in top, there is no basis for all that. Whatever it provides will govern you. That was the theory. And here the Dicey's doctrine of that supremacy of parliament is being spoken to. If you're not able to open it, I'll just read it, Shyam.
Sir, it's not opening, sir.
Okay. So he says, I'll just read it. If the Attorney General is right, the 1949 Act could also be used to introduce oppressive and wholly undemocratic legislation. For example, it could theoretically be used to abolish judicial review of flagrant abuse of power by a government, or even the role of the ordinary courts in standing between the executive and citizens. This is where we may have to come back to the point about the supremacy of parliament. They touched upon a very important issue, and they say the classic account given by Dicey of the doctrine of the supremacy of parliament, pure and absolute as it was, can now be seen to be out of place in the modern United Kingdom. Nevertheless, the supremacy of parliament is still the general principle of our constitution. It is a construct of the common law. The judges created this principle. If that is so, it is not unthinkable that circumstances could arise. This is exactly where they touch upon basic structure. The circumstances could arise where courts may have to qualify a principle established on a different hypothesis of constitutionalism in exceptional circumstances involving an attempt to abolish judicial review or the ordinary role of the courts. The appellate committee of the House of Lords or the new Supreme Court may have to consider whether this is constitutional, fundamental, which even a sovereign parliament acting at the behest of a complacent House of Commons cannot abolish. This according to you is a very important landmark in England, which means that even a country which does not have a constitution. A country with an unwritten constitution has gone to the extent of saying this. So to conclude, I would say that the Kesavananda by itself, it's a case of Kesavananda becoming so popular without getting a relief. Sometimes its operation success and patient collapses. This is exactly what happened to Kesavananda also. But then what is important is not to see who succeeded and who failed. But what is important is to see, as Premraj rightly said, is that the country was saved and the supremacy of whom? The supremacy of the constitution was established. So there is no use in this country in saying that parliament is supreme, court is supreme, executive is supreme. Nobody is supreme. It is the constitution which is supreme, and the basic structure of that constitution was sought to be restored by this judgment. Thank you so much. Thank you. Thank you.
Thank you very much, sir.
Thank you, sir.
Indeed, wonderful. Sir, Kurian sir, you want to add something, or can I go to Roshan Dalvi, ma'am?
No, please give a chance to our sister. Sister is impatiently waiting. I can see.
Roshan Dalvi, ma'am, please. You let unmute.
It is at last my turn, and I have been dazed. I have called Premraj the rising star, and I maintain it. It is so good of Shyam as well as Premraj to give us this exposition. Three things come out of it, as I would say. One is that there were two roads well traveled, and India chose the better road of democracy against autocracy. Second is that it held that you can amend the letter of the law, and that law was the supreme law, the Constitution. You can amend all the articles of the Constitution, but not the spirit of the Constitution. So the spirit towered over the letter. The third was how we move from precedent to precedent, as Alfred Lord Tennyson had said. In the land of great reform, we move from precedent to precedent. And we here moved from Shankari Prasad to Sajjan Singh, to Kesavananda Bharati, to Indira Gandhi, and all through up to NJAC and the 103rd Amendment. And this is how we have come to flourish. It is providence that such judges as those 7 judges gave us our real freedom. Thank you.
Thank you, ma'am.
Meanwhile, now that we have got Justice Rajendran also here, sir, what about you, sir?
Very good evening to all. Nice to see you all after a long time. For me, of course, I've not joined earlier. That was something remarkable, wonderful. I could not say a person could assimilate the entire judgment in less than 1 hour. We have read through long time since, but then this total assimilation in such a wonderful words and to the down to earth finding. I will use the word finding because he has culminated all the other judgments also to ultimately see what is the net effect of it. Thanks to Honorable Justice Kurian Joseph, who's here. Very well done by Prem. Prem, really, your work has been superb. We have gone through this judgment very many times, but the analysis would not have been done this much. We have heard many people on this, and I would only say this is the best out of the many hearings which I have done, including one done in the National Judicial Academy by a senior judge. You have done a very good job. Thanks to Prem and Sam to Shyam for inviting. And I narrowly missed it. At 5:30, I missed your link. I could got join by 5:40, but every minute was wonderful. Thank you all, and thank you everyone.
Thank you, Justice.
Thank you, sir.
Thank you very much. After we met in Bangalore, I think it's long time that we are not met again. You've been in US, Justice Paramjit, sir. Over to you.
Yes, sir. First of all, I congratulate Mr. Premraj for his presentation. Before wasting much of the time, I will just I consider what I have, I feel there are issues with regard to the supremacy of the parliament or the constitution. Does the parliament really represent the combined will of the people of the nation? These are the issues. Can we trust the majority government? What are the possibilities we can imagine in the present state of affairs? There is no super constitutional norm on the basis of which the amendments can be tested. When we will have to look into all these things, what is to be seen? Constitutional issues, amendments are to be tested on the basis of social, economic, and political situation. The choice is not always purely legal. We will have to look into, because what is the spirit of the constitution, we will have to look into that. This is what I feel, and the larger issues are required to be seen. Now we have seen what the law minister was saying, Mr. Raju was saying. He said, I feel that Supreme Court has not, what I was looking into, accepted the will of the people in India, of India. This is what he said. Now, if we look into the past history of various other countries, as Mr. Menon, Mr. Premraj has referred to the Weimar's Germany issue, possibility in this country is also not ruled out. If this judgment would not have been there, their consequences would have been otherwise. Possibility tilting toward the dictatorship is not ruled out. This is what I understand. Now, if we look into the function of judiciary, is not just to be cognitive in understanding the laws like this. When we talk of constitutionalism, then necessarily it entails that judiciary itself be regarded as an important part of law validation process. When judiciary itself is a part of the law validation process, then what we will have to look into. In this sense, when rules are made, passed through process, it may be validly passed. Then who will test it? It is only the judiciary which will have to determine about these things and then come to a conclusion whether it is in consonance up. All the laws of the society did not emanate from the legislature. We have to keep the legal and political order both in proper order. Political house is also to be taken care when they are framing such laws. So I did that. Another issue with some debate Mr. Shyam will create on this. We will have a participation in that regard. Already much time has been flowed. So I will say thank you for the informative session we had. Another thing which I say, Brother Joseph was there in the NJC versus collision. That issue, now you will imagine what is happening. Whether in the present situation, what type of the judges will be manning the courts of law. It is also another issue, which I am not deliberating here, but sometime this will also come in such a platform. Hopefully, the eminent persons and judges, honorable judges, retired, specifically the retired, who has a say in this, they can say at present now, they will certainly deliberate on this also. Thank you very much for affording me opportunity, because I was out of India, so I could not participate in the earlier. Thank you very much, Mr. Shyam, for that.
Thank you, sir. It's just wonderful to have you here.
And I only said that we can dedicate session number 300 for this issue on appointment.
Yes.
Probably I did not get the chance to write a codicil. That is something which I missed.
Sir, postscript judgments are also required to be for the retired judges. There should be some.
No, I only just wanted to add one codicil here.
Yes.
That I think in Manoj Narula, the constitutional judgment I said,
Yes.
What the constitution is, it is for the judiciary to say. What
Yes.
the constitution should be, probably it is for the parliament to say, because
That's
the parliament itself is the creature of the constitution. So therefore, then bound by the constitution. So to judiciary, no doubt about it. But
yes.
But to interpret the constitution, the constitution itself has exclusively vested it to the judiciary. That's final word as the guardian of the constitution. This is just a clarification I wanted to say.
That's right.
So we have a codicil on that. Thank you, sir. Ramkumar, sir, please.
Oh, what can a confirmed criminal say about constitutional issues? Excellent presentation, elucidation, and analysis by Mr. Premraj Menon, who has not left any stone unturned. Really captivating and bewitching. Premraj is undoubtedly a ready reckoner and a walking encyclopedia. We had one in Mr. Achudurni, who is no more. He was a ready reckoner in our district judiciary. Sad to say that he is no more. He ought to have been in the High Court. Anyway, it was really beautiful, excellent. I think it was in Kesavananda Bharati that they said for the first time that this preamble is also part of the constitution.
Yes.
Disagreeing with the earlier view. Is it not?
It's not disagreeing. Actually, it said that the preamble is a basic structure.
And it is also part of the constitution.
It's a part of the
Otherwise,
constitution.
the earlier view was that preamble is never part of the statute.
Preamble, it need not be read into the constitution.
Yes. I think very, very captivating lecture. Thank you. Thank you
so
for
much,
educating me.
Thank you.
I'm humble,
Thank you, Ramkumar, sir. This is Ramashan, sir.
Hearing Premraj is always a pleasure, because you will get all things under the sun when you analyze a decision of such nature. As rightly said by all the participants, that the basic structure of constitution has been used for the purpose of testing the parliamentary power of amending the laws also. And some of the comments have come whether this can be used for the other legislatures. But the Supreme Court in Kesavananda Bharati itself has said, when you are considering the other laws, you will have to look into these aspects as to whether it goes to the root of the constitution itself or basic principles of the constitution itself. So that is how it was framed in such a way that is never left anything to be considered later. Only thing is, what is supreme is constitution. You cannot go beyond that. And anything done affecting the right of the parties, which is envisaged in the constitution, is bad. That is how it has been dealt with in the Kesavananda Bharati case, which I understood in a limited sense, because I am not a constitutional lawyer. I never appeared before the High Court. We had no opportunity to consider the power of the High Court under Article 226 and Article 32 of the Constitution by the Supreme Court. So this is where even Article 32 itself was intended for the purpose of judicial review. Whenever certain things are being done for the purpose of benefit of the persons, or any law has been created by any legislature or by the parliament itself, if it goes to the root of the fundamental matters which affects the basic principles of the basic principle doctrine, the basic structural doctrine, then it will be bad. That is what ultimately it was found. It was being followed now in almost all the cases. Even now it is untouched. For the last 50 years, it tests the time, and it is still found that it is a good law to follow also. Thank you very much.
Thank you, sir.
Thank you very much, Justice Ramashan, sir. And thank you, all of you. And as we started this lecture with the introduction by Justice Kurian Joseph, sir, maybe you have the honor of the conclusion also at your hands, sir.
Thank you, Shyam. I only said in Kesavananda Bharati, it was said that preamble can be referred to as a source for interpreting the constitution. That was what was held in Kesavananda Bharati. And for the first time, secularism was said to be a basic structure.
Yes.
That is also a contribution, according to one of the greatest contributions of course, Kesavananda Bharati. Thank you, dear sisters and brothers and friends. Such an illuminating thing. It's very difficult to understand Kesavananda Bharati in such a short time. Not only Kesavananda Bharati, Prem did a wonderful other contribution to us, that how Kesavananda Bharati has been understood, interpreted, and taken for the jurisprudential growth, as Sister Roshan rightly said, for maintaining this nation, actually, to this level, up to this level. Rather, Sister used the word for saving the nation. Say, I also endorse that expressions also. So, thank you very much, because this is what India is. Our nation has reposed so much of faith in the Constitution, and the Constitution's guardianship has been given to the judiciary, and probably that was Court of India. I only wish and pray that people who are there realize this grave duty cast on them to be the real guardian, to guard the Constitution, to guard the nation. Thank you once again to all of you. God bless.
Thank you very much.
Thank you, sir. Thank you so much.
Students of law and as social engineers, let us forge ahead, inspired by the glorious past, enthused by the contemporary zeal, and enthralled by the clarion of the future. Thank you very much, everybody. Till we meet again next time, please do take care and stay safe. Good night.